On February 20th, 9 Supreme Court justices did something no court had ever done to a sitting president's signature economic policy. They erased 70% of it in a single ruling. The fentanyl tariff on Canada, the 25% charge that had been landing on this border since last year, gone in the same stroke as tariffs on dozens of other countries. If you've watched this channel cover Section 338, Section 301, the wildfire smoke fight, the 50% deadline, all of it traces back to this one morning because everything that came after was Washington scrambling to replace what this ruling took away. And that's not an abstract legal story sitting somewhere in a courthouse. It's the reason the price on a Canadian car part, a bottle of wine, a block of cheese kept moving all year, even while headline after headline told you the tariffs behind it had just been struck down, because getting struck down in a courtroom and actually stopping at the border turn out to be two very different things, as you're about to see. Subscribe before we get into this, because the version of this story most channels are telling skips the 4 days that actually decided how the rest of the year played out. And drop a comment right now. If a court rules a tariff illegal and the government keeps collecting it anyway, is that still the rule of law? Let's get into it. Start with what actually got struck down, because the number involved is bigger than most coverage let on. The law was the International Emergency Economic Powers Act, IEEPA for short, a 1977 statute written to let a president freeze the assets of an enemy state or sanction a hostile regime during a declared national emergency. Beginning in 2025, the administration used it for something the law had never been used for once in its entire history: to impose tariffs on nearly every country the United States trades with, justified as emergency responses to trade deficits, fentanyl trafficking, and a declared international payments crisis. By early 2026, IEEPA tariffs made up roughly 70% of the entire tariff structure the administration had built. The fentanyl charge on Canada, the so-called reciprocal tariffs on dozens of other countries, nearly all of it resting on one single legal foundation. That foundation went to the Supreme Court as Learning Resources versus Trump, argued November 5th, decided February 20th, and decided decisively. 6 justices to 3. Chief Justice John Roberts wrote the majority opinion, joined in full by Justices Gorsuch and Barrett, joined in part by Sotomayor, Kagan, and Jackson. Thomas, Alito, and Kavanaugh dissented. The reasoning came down to one distinction the government's entire tariff program had leaned on for a year. IEEPA lets a president regulate trade during an emergency. It does not let him tax it. The power to impose a tariff is, in the court's own words, a branch of the taxing power, and the Constitution puts that power in Congress's hands, not the president's, no matter how the emergency is worded. Regulating and taxing sound like the same authority from the outside. The court said they have never been the same power, and Congress never handed the second one away. Think of it the way the court itself framed it. Telling a company it cannot ship a product to a sanctioned country is regulating trade. Charging every company a fee to ship anything at all to anyone is taxing it. And only one of those two things has ever required an act of Congress. Learning Resources versus Trump did not travel to the court alone. It arrived alongside a companion case, Trump versus VOS Selections, brought by a separate group of importers hit by the same emergency tariffs, and the court folded the two together into one ruling covering both. That matters beyond the legal footnote because it meant the decision wasn't resting on one company's narrow set of facts. It was a ruling about the tariff power itself, applying the same way to every importer in every state hit by any tariff that traced back to IEEPA, Canada's fentanyl charge included. Rulings that erase a sitting president's signature economic program outright are rare enough that legal commentators spent the following weeks debating when the court had last done anything comparable. Most of them couldn't point to a clean precedent. That's how unusual February 20th actually was. The reaction from the White House arrived within hours, and it wasn't measured. Asked directly whether he regretted nominating 2 of the justices who ruled against him, the president didn't hedge. Quote, "I think their decision was terrible. I think it's an embarrassment to their families. You want to know the truth." The two of them, end quote, aimed squarely at Gorsuch and Barrett, his own appointees. Behind the anger sat a number large enough to explain it. Roughly $166 billion in tariffs had already been collected under the law the court just voided, and the ruling opened the door to importers clawing some of it back, a refund fight so large the court itself left the hardest part of the question, who actually gets paid and how, unresolved. That combination, a program worth well over $100 billion and two of his own appointees on the losing side of the vote, is the actual context for how fast what came next moved. This wasn't a White House that treated the ruling as a final word to be absorbed and negotiated around over the following weeks. It was treated as a problem to be solved before the news cycle covering it even finished running. Here's the part almost nobody outside a trade law firm noticed happen in real time. The same day the ruling came down, the White House was already moving. Trump signed a proclamation invoking Section 122 of the Trade Act of 1974, a provision built for something narrow, letting a president impose a short-term import surcharge, capped at 15%, for up to 150 days to address a genuine balance of payments emergency. A 10% version of that surcharge went into effect at 12:01 a.m. on February 24th. Count the days, February 20th to February 24th. 4 days from the ruling that erased 70% of the tariff program to a new tariff already collecting money at the border. That is where the phrase comes from, and it's real. What most coverage gets wrong is what actually got rebuilt in that window, and it matters more than the speed. Section 122 is not the 1930 law this channel has spent months tracking. It's a 1974 provision, a temporary bridge, not a permanent replacement, and its own text puts a clock on it the moment it's invoked, 150 days, no extensions written into the statute. The president said as much himself the next day, posting on Truth Social, that he intended to push the surcharge from 10% up to the full 15% ceiling the law allows, and it moved there within weeks. But a temporary surcharge with an expiration date was never going to be the whole plan. The administration's own statement made the second track explicit almost immediately. The government would, quote, invoke alternative legal authorities to replace the IEEPA tariffs, end quote, specifically naming Section 232 and Section 301, authorities officials described as, quote, validated through thousands of legal challenges, end quote. Section 122 bought 4 days of headlines. It was never built to be the permanent answer, and everyone signing it knew that going in. So what did that mean for Canada specifically, the country whose fentanyl tariff had just been erased along with everything else? For a few months, nothing changed at the border beyond the flat 10, then 15% global surcharge every trading partner was now paying. Behind the scenes, something narrower and far more durable was being built, aimed at Canada alone. On July 20th, 5 months after the ruling, 3 separate presidential proclamations invoked Section 338 of the Tariff Act of 1930, a law that had not been used to impose a single tariff since 1949, covering automobiles, dairy, and alcohol, a 50% duty landing specifically on Canadian goods. If you watch this channel's coverage of that day, you already know the legal weaknesses buried inside it. The missing International Trade Commission investigation. The argument that a newer 1962 law effectively replaced the old one. What that video didn't have room to explain is why the administration reached all the way back to a 1930 statute in the first place. This is why. Section 122 was never built to survive. And everyone drafting Section 338 in the months after February already knew it. There's a reason Canada specifically got a dedicated law instead of just writing the global surcharge everyone else was paying, and it isn't only legal strategy. Of every trading partner touched by the IEEPA ruling, Canada was the one Washington kept naming individually all year, in the fentanyl order, in the autos and dairy and alcohol proclamations, in a way dozens of other affected countries never were. A flat global rate treats every country the same. A law reached back 77 years and dusted off specifically for one neighbor sends a different message entirely, and whichever side of this trade war you're watching from, That's the part worth sitting with. The administration had a fast, generic option sitting right there in Section 122 and chose to also build a slower, custom one aimed at exactly one country. And they were right to worry because Section 122 didn't survive either. On May 7th, the Court of International Trade ruled 2-1 that the 10% global surcharge wasn't lawful in the first place. The court found the administration's own justification, a so-called balance of payments emergency, didn't match what Congress actually meant by that phrase back in 1974, specific deficits in liquidity or official settlements, not a general sense that trade felt unbalanced. The distinction sounds technical, but it's the same move the Supreme Court had just made 3 months earlier, applied to a different statute. IEEPA let a president regulate, not tax. Section 122 let a president act on a specific, definable balance of payments crisis, not a broad general feeling that trade wasn't going the country's way. 2 different laws, 2 different courts, and both times the government's actual justification turned out to be broader than the specific thing the statute was written to cover. A second tariff program struck down by a second court less than 3 months after the first one. Here's the detail that should bother you more than the ruling itself. The court didn't strike the tariff down for everyone. It only permanently blocked it and ordered refunds with interest for the 2 companies that actually sued and for the state of Washington. Every other importer in the country kept paying a tariff a federal court had just called unlawful because they weren't a named party to that specific case. The government appealed the next day, and on May 12th, the Federal Circuit issued a stay, putting even that narrow ruling on hold while the appeal plays out. So, as of right now, a court has ruled Section 122 unlawful, and the tariff is still being collected from almost everyone paying it, a court's own word sitting there unenforced against anyone who didn't personally show up to argue their case, which brings the story back around to a date this channel has already covered from the other direction. Section 122's own statute gave it a 150-day clock, starting the moment it took effect at 12:01 a.m. on February 24th. Run that clock forward and it expires at 12:01 a.m. on July 24th. The exact same instant Section 30160 economy tariff wave, the one this channel covered as 99.4% of everything America imports, took over. One law's legal lifespan ran out at the precise second its replacement activated. Nobody scheduled it that way on purpose. It's just what happens when a temporary patch with a hard statutory deadline gets handed off to the permanent structure being built underneath it the whole time. Watch the calendar closely enough and the entire strategy stops looking like chaos and starts looking like a relay race, one runner's legal clock expiring exactly as the next one's hand closes around the baton. Lay the whole year out end to end, and the pattern is impossible to miss. February 20th, the Supreme Court erases the tariff program built on IEEPA. February 24th, a temporary patch goes live under a 1974 statute with its own built-in expiration date already ticking. May 7th, a second court rules that exact patch unlawful too, blocked only for the 2 companies and 1 state that sued. May 12th, an appeals court freezes even that narrow ruling, and the money keeps flowing regardless. July 20th, the administration reaches back to a law from 1930 that hadn't been touched in 77 years to build something aimed specifically at Canada. July 24th, the temporary patch's own clock runs out at the identical instant its permanent replacement takes over everywhere else. That's not 1 setback and 1 comeback. That's 5 separate legal events in 5 months, and the tariffs never actually stopped moving through any of it. Translate that into something that shows up on an actual receipt. Every one of those 5 dates represents a different legal basis for the same dollar amount landing on the same imported good, which means the price tag on a Canadian car part, a bottle of wine, a block of cheese, never really depended on which specific law was technically enforced that week. It depended on whether any court order actually stopped collection at the border. And so far, across 5 separate rulings touching 2 separate statutes, none of them fully has. The importer paying the bill doesn't get to wait for the appeal to resolve before the invoice comes due. A customs broker clearing a shipment at the border isn't handed a footnote explaining which of 5 legal fights that day's duty technically rests on. They're handed a number, and the number gets paid or the container doesn't move. A small auto parts distributor bringing Canadian-made components across the line every week has had to recalculate that landed cost 5 separate times this year, once for each date on that list, regardless of which court, on which side, said what about the law behind it? That's the part a legal timeline leaves out and a shipping invoice never does. So here's what actually determines how this settles from here. First, watch what the Federal Circuit does with Section 122 once it rules on the merits, not just the stay, since a final decision there could force real refunds for far more than 2 companies and 1 state. Second, watch the $166 billion IEEPA refund question, still sitting unresolved 5 months after the ruling that created it, because a government forced to write that check has a very different set of incentives than one that isn't. Third, watch whether Section 338's own legal weaknesses, the missing investigation this channel already flagged, get argued in court before its own deadline arrives, the same pattern that's now played out twice with IEEPA and Section 122. Fourth, watch whether any of these rulings ever actually stop collection at the border in real time, rather than promising a refund months or years after the fact, because that gap, ruled unlawful versus still being collected, is the actual story running underneath every one of these headlines. And fifth, watch Congress, because the court's own opinion left the door open exactly one way. If lawmakers want the president to have clear tariff power, they can pass a law that says so in plain language. Nobody in Washington has introduced that bill yet. Until someone does, every one of these fights keeps happening in courtrooms instead of in a single vote, which is exactly why this keeps taking 5 months and 5 separate rulings instead of 1. None of this is finished. A law is not the same thing as a ruling, and a ruling is not the same thing as money actually stopping at the border. And this year has now proven that gap 3 separate times over 5 months, with a 4th fight already teed up around the very law this channel has been tracking since July. What's actually settled is this. The tariff regime that reshaped this entire trade war didn't survive on any single law surviving a single court challenge. It survived by having a replacement ready before the ink dried on the ruling that killed the last one, 4 days the first time, 5 months the second time, and apparently as many more rounds as it takes. And once that pattern works once, there is nothing about it specific to Canada and nothing about it specific to this administration. A future president of either party facing a court loss on any economic emergency power now has a working template sitting in plain view. Don't fight to save the law that lost. Replace it before the cameras finish covering the ruling. That's where this stands right now. If you want the version of this story that actually connects the dates instead of covering each ruling as its own isolated headline, this is exactly why this channel exists. Subscribe and drop a comment below. When a court rules a tariff unlawful and the government keeps collecting it anyway pending appeal, does that still count as the rule of law working? Or is that the system quietly admitting the rule doesn't matter until someone with enough money to sue makes it matter? Let me know what you think, and I'll see you in the next one.